Alright. Let's get this going. Alright. Alright. So, going back to this, you'll have to go to YouTube or Twitch because TikTok won't let me show this, but we are doing the Federalist Papers. These are the beginning of... oh, let me send this message real quick. So these are what Hamilton, mainly Hamilton. There were some other writers in the Federalist Papers, but it was mainly Hamilton. He was writing the Federalist Papers because, all right, so we just wrote the Constitution. We're trying to get all the states to verify it. We're trying to get them to ratify the Constitution. And, you know, not all the states are doing it. Some are dragging their feet. And they're like, okay, you wrote this thing. Why should we ratify this? And so they wrote the Federalist Papers. And they were like, okay, these are defense of the Federalist Papers. We think these are good ideas. These are our defense. This is why we wrote this in Article 1 or this in Article 2. And, all right. And now we're on 77 out of, I think there's like 85. Yeah, there's 85. So we got like 8 more to go. So I'm going to try to hit another hour on this. Try to get more of this going. All right. Actually, let me... All right. Okay, number 77. Appointing power continued and other powers of the executive considered. All right, so we are deep into Article 3 of the Constitution of his defense, the executive power. And we're going, okay, why does the executive have these powers? Why did we not give this or that power to the Senate? Why did we not give this or that power to the executive? Why are these split? And basically that's what they're doing for. All right. Okay. It has been... Whoa, this just happened. Okay, that was weird. It has been mentioned that one of the advantages to be expected from the cooperation of the Senate in the business of appointments is that it would contribute to the stability of the administration. The consent of the body would be necessary to displace as well as appoint. A change of the chief magistrate, in this case the president, therefore would not occasion so violent or so general revolution in the officers of the government as might be expected. If he were the sole disposer of offices, where a man in any station had given satisfactory evidence of his fitness for it, a new president would be restrained from attempting to change in favor of person more agreeable to him, by the apprehension that a discountenance of the Senate might frustrate the attempt and bring some degree of discredit upon himself. Those who can best estimate the value of a steady administration will be most disposed to prize a provision which connects the official existence of public men with the approbation or disapprobation of the body, which, from the greater permanency of his own composition will in all probability be less subject to the inconsistency than any other member of the government. All right, so he's setting up his argument right now. To this union of the Senate with the President in this article of appointments, it has in some cases been suggested that it would serve to give the President an undue influence over the Senate, and in others that it would have the opposite tendencies, a strong proof that neither suggestion is true. All right, so he is setting up, Hamilton likes to do this, he likes to set up his opposition's point of view, and then he will go like, okay, this is why I disagree with this is why this is not a big of an issue. To state the first in its proper form is to refute it. It amounts to this: the President would have an improper influence over the Senate, because the Senate would have the power of restraining him. This is an absurdity in terms. It cannot admit of a doubt that the entire power of appointment would enable him such more effectually to establish a dangerous empire over that body than a mere power of nomination in the subject of control. All right, so the President, if you don't know, the President has the right to make appointments, but the Senate, 2/3 of the Senate, has to approve of them. Let us take a view of the converse of this proposition. The Senate would influence the executive, as I have had occasion to remark in several other instances. The indistinctness of the objection forbids a precise answer. In what manner is this influence to be exerted? In relation to what objects? The power of influencing a person, in the sense that in which it is here used, must imply the power of conferring a benefit upon him. How would the Senate confer a benefit upon the President by the manners of employing the rights to negate upon his nomination? If it to be said that they sometimes gratify him by an acquiescence in a favorable choice, when the public motives might dictate a different conduct, I answer. Okay, so the Senate has the power to approve the President's choices. So the argument that people are making is that, hey, they could try to give favors to the President by approving his choices. Okay. And his response is that the instances in which the President could be personally interested in the result would be too few to admit of him being materially affected by his compliances of the Senate, the power of which can originate the disposition of honors and annulments, is much more likely to attract than be attracted by the power, which can merely obstruct their course. By influencing the President, be meant restraining him, this is precisely what must been intended, and it must be shown that the restraint would be salutary, at the same time that it would not be such to destroy a single advantage to be looked upon the uncontrolled agency of that magistrate. The right of nomination, so the President makes the nomination, would produce all the good of that appointment and would be in great measure to avoid its evils. So the President has the opportunity, but also the downside of making the appointment, because it is his appointment. On a comparison of the plan for the appointment of officers of the proposed governments with which it is established by the Constitution of this state, a decided preference must be given to the former, in that a plan, the power of nomination is unequivocally vested in the executive, and as there would be a necessity for submitting each nomination to the judgment of an entire branch of the legislature. The circumstances attending an appointment, from the mode of conducting it, would naturally become matters of notoriety, and the public would be at no loss to determine what part had been performed by the different actors. The blame of a bad nomination would fall upon the President, singly and absolutely. So the President gets the blame. So this was written straight, like it is the President's fault if he makes a bad nomination. This was their intention. The censure of rejecting a good one would lie entirely at the door of the Senate, and the Senate gets the benefit for approving the President's good picks. Aggravated by the consideration of having contradicted the good intentions of the executive, if a ill appointment should be made, the executive for nominating and the Senate for approving would participate, though in different degrees, in the opprobrium and disgrace. So the Senate would get some blame, but the president would get the lion's share. The reverse of all this characterizes the manner of appointments in this state. The Council of Appointments consists of 3 to 5 persons, of whom the governor is always one. This small body, shut up in a private apartment, impenetrable to the public eye. So he's making a comparison to the way New York chooses its offices to how the Constitution decides that the United States will choose its offices. Proceeds to the execution of the trust committed to them. It is known that the governor claims the right of nomination upon the strength of some ambiguous expressions in the Constitution, but it is not known to what extent or in what manner he exercises it, nor upon what occasions he is contradicted or opposed. The censure of a bad appointment, on account of the uncertainty of its author, and for want of a determinate object, has neither poignancy nor duration. And while the unbound field for cabal and intrigue lies open, all ideas of responsibility is lost. The most is that the public can know is the governor claims the right of nomination, that 2 of the inconsiderable number of 4 men can too often be managed without much difficulty, that in some of the members of particular council should happen to be uncomplying character. All right, so he's still making the comparison between the New York. He's pointing out all the problems with the New York's idea of how they choose offices and saying, like, hey, this is how we do it better. This is the improvements we made on this state's choices in the big Constitution. It is frequently not impossible to get rid of their opposition by regulating the times of meeting in such a manner as to render their attendance inconvenient, and that whatever cause it may proceed, a great number of very improper appointments are from time to time made. Whether a governor of this state avails himself to the ascendant he must necessarily have in this delicate and important part of the administration, to prefer to officers of men who have best qualified for them, or whether he I think I'll get in trouble if I say this word. If he sells himself out that advantage to the advancement of persons whose chief merit is their implicit devotion to his will, and to the support of a despicable and dangerous system of personal influence, are questions which, unfortunately for the community, have only been the subjects of speculation and conjecture. Every mere council of appointment have constituted will be a conclave in which a cabal intrigue will have their full scope. Their number without an unwarrantable increase of expense cannot be large enough to preclude a facility of combination. All right, so we don't want to have these, like, we don't want to pick a council of, like, small amount of men, women to make these choices for appointment, even though, you know, some people are saying we need to have like a group of experts choose these experts. And it's like, we need to do it out in the open, and we need to have a big section of the Senate to choose this, so there's not this, there's less chance of like cabals and like backroom dealings, and you have it out in the open so you can see what's happening. And as each member will have its friends and connections to provide for, the desire of mutual gratification will beget a scandalous bartering of votes and bargaining for places. The private attachments of one man might easily be satisfied, but to satisfy the private attachments of a dozen or 20 men, or nowadays 60, would occasion a monopoly on all the principal employments of the government in few families, and would lead more directly to an aristocracy or oligarchy than any measure than could be contrived. If to avoid an accumulation of offices, there were to be a frequent change in the persons who were to compose of the council, this would involve the mischiefs of a mutable administration in their full extent. Such a council would be more liable to execute influence than the Senate, because they would be fewer in number, and would act less immediately upon the public inspection. Such a council, in fine, as a substitute for the plan of convention, would be productive of an increase of expense and multiplication of evils which spring from favoritism, intrigue, and the distribution of public honors. a decrease of stability in the administration of government, and the dominion of the security against the undue influence of the executive. And such a council has been warmly contended for an essential amendment to the proposed constitution. I could not without propriety conclude my observations on the subject of appointments without taking notice of the scheme for which they have appeared to some, though but few advocates. I mean that of the uniting of the House of Representatives and the power of making them. I shall, however, do little more than mention it, as I cannot imagine that is likely to gain a countenance of any considerable part of the community. A body so fluctuating at the time and so numerous can be deemed proper for exercise of power. Its unfitness will appear to manifest to all when it's recollected that half a century it may consist of 300 or 400 persons. Hamilton, he kind of realized that how big, he's like, they really did think I wonder if they would be really kind of disappointed about the size of the House of Representatives. According to Hamilton, it should be hundreds more people. All the advantages of the stability, both of the executive and of the Senate, would be defeated by this union, and infinite delays and embarrassments would be occasioned. The example of most of the states of their local constitutions encourages us to reprobate the idea. The only remaining powers of the executive are comprehended in giving information to Congress of the state of the Union, and recommending to their consideration such measures as he shall judge expedient, in convincing them of either branch upon extraordinary occasions, in adjuring them when they cannot themselves agree upon the time of adjournment, in receiving ambassadors and other public ministers, in faithfully executing the laws, and in commissioning all officers of the United States. Except some cavils about the power of convening either house of the legislature, and that receiving ambassadors, no objection has been made to this class of authorities, nor could they possibly admit any. It is required, indeed, an insatiable avidity for censure to invest exceptions to the parts to which has been expected too. In regard to the power of convening either house of the legislature, I shall barely remark that in respect to the Senate at least, we can readily discover a good reason for it, as this body has a concurrent power with the executive in the article of treaties. It might often be necessary to call it together with a view to this object, which would be unnecessary and improper to convene the House of Representatives. As to the reception of ambassadors, what I have said in the former paper will furnish sufficient answer. All right, he's already gone over why we don't want the House of Representatives being the ambassadors of the country. We'd rather have senators do that because they're there longer. They have more time to develop foreign relations, and they're not as sway as the House of Representatives. We have a more completed and survey of structure and power and of the executive department, which I have endeavored to show combines, as far as Republican little r principles will admit it, all the requisites to energy. The remaining inquiry is, does it also combine the requisites to safety in a little r Republican sense, a due dependence on the people and due responsibility? The answer to this question has been anticipated in the investigation of its other characteristics, and is so satisfactorily deductible from these circumstances, from the election of the President once in 4 years by persons immediately chosen by the people for that purpose, and from his being at all times liable to impeachment, trial, dismission from office, incapacity to serve on any other, and forfeiture of life and estate by subsequent prosecution in the common course of law. This was one thing that Hamilton, that I did not realize, that Hamilton wrote a lot about in these Federalist Papers. He was completely convinced that that impeachment was going to happen a lot more. That if somebody was doing something shady, they would be impeached. That it wasn't going to be this rare and really extreme circumstances thing. It's you're doing bad, you did something bad, you're out. It's fine. We'll move on. Every way he writes about it, it was never meant to be this rare, oh my God, somebody got impeached. That's crazy. It's he sucked, get him out. But these precautions, great as they are not the only ones in the plan of the convention has provided in favor of the public security. In the only instances in which the abuse of the executive authority was materially to be feared, the Chief Magistrate of the United States would, by that plan, be subject to the control of a branch of the legislative body. What more could be desired by an enlightened and reasonable people? Publius. All right, so that's number 77, is defense of how they set up appointments. All right, so we are done with the executive branch after 77. He's now moving on to the next article, the Constitution, the judiciary, and how the Supreme Court was. This is going to be interesting because how the Supreme Court is today is a lot different than it is written in the Constitution. So I'm curious what they say about the Supreme Court in that case. This is also going to be Hamilton to the people of New York. Most of the writing first is to New York. That's where he was living. So if New York ratified the Constitution, a lot of other states would too. New York was a very powerful state, as it is today. So if New York did, a lot of the other Northeast states would also ratify. Hamilton, to people in New York. We proceed now to examine the judiciary department of the proposed government. In unfolding the defects of the existing Confederation, they were still under the Articles of Confederation, the utility and necessity of federal judiciary has been clearly pointed out. It is less necessary to recapitulate the considerations there urged, as the propriety of the institution in the abstract is not disputed, the only questions which have been raised being relative to the manner of constituting it, and to this extent, to the points therefore, our observations shall be confined. All right. The manner of constituting it seems to embrace the several objects are: first, the mode of appointing the judges; 2, the tenure by which they hold their places; 3, the partition of the judiciary between the different courts and their relations to each other. All right, so 1, we have how we appoint judges; 2, how long are they judges; 3, the walls, the breaks between the judiciary and the other branches and the other different layers of court. Yeah, I would say so. Yeah. All right. First, as we are on appointment, the first point, appointments of judges. As the mode of appointing the judges, this is the same with that of appointing the officers of the Union in general, which he just spent the last 3 papers writing about. How the president chooses that, the Senate confirms why he chose to write it that way. All right. And has been so fully discussed in the last 2 numbers that nothing can be said here which would be useless repetition. Okay, so even he says it. He's like, it's going to be useless repetition if I go over this again, but now with judges. We just read 2 whole long ones about why we do appointments this way. It would be repetition to do it here. Second, their tenure. As to the tenure by which the judges are to hold their places, this chiefly concerns their duration in office. The provisions for their support, the precautions for their responsibility. According to the plan of the convention, all judges who may be appointed by the United States are to hold their offices during good behavior, in quotes, which is conformable to the most approved of the state constitutions among the rest. To that of this state, meaning New York, it is... What is this? Propriety? Its propriety, having been drawn into question by the adversaries of this plan, is no light symptom of the rage for objection, which disorders their imaginations and judgments, the standard of good behavior for the continuance in the office of the judicial magistrate. It is certain one of the most valuable and modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is no less excellent barrier to the encroachments and oppositions of the representative body, and it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of laws. All right, he's giving the reasons why courts are good. Whenever attentively considers the different departments of power, must perceive that in government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous of the political rights to the Constitution. Ooh, that's a big claim, Hamilton. All right, because, let's see his defense, because it will be least in capacity to annoy or injure them. This is one thing that has completely flipped upside down in modern days. The Supreme Court was supposed to be the absolute weakest branch, and the legislature was supposed to be the strongest. And right now, the legislature is by far the weakest branch. And, you can make an argument that the executive or the judiciary might be even more powerful at this point. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, which it doesn't right now, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of society, and can take no active resolution whatsoever. Whew, that's rough thinking about today. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments. The simple view of the matter suggests several important consequences. It proves incontestably, let's go with that the judiciary is beyond comparison the weakest. He even comes out right and say it is the weakest branch, or it's supposed to be, of the three departments of power, that it can never attack with success the other two, and that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that quarter. I mean, so long as the judiciary remains truly distinct from both the legislature and the executive. For I agree that there is no liberty if the power of judging be not separate from the legislature and executive powers. And it proves in the last place that liberty can be nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. That as all the efforts of such a union must ensue from the dependence of the former on the latter, notwithstanding a normal and apparent separation, that as from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches, and that as nothing can contribute so much to its firmness and independence as permanency in office. This quality might therefore be justly regarded as indispensable ingredient in its constitution, and in its great measure as the citadel of public justice and the public security. All right, so he's laying out, he's like, all right, these are the why we need to protect the judiciary branch, because it is supposed to be very weak. The Supreme Court is supposed to be very weak and feeble and be like, please protect me, other branches. Even though in modern times might be the strongest branch. The complete independence of the courts of justice is particularly essential in a limited constitution. By a limited constitution, I understand one which contains a certain specified exceptions to the legislative authority, such, for instance, as it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenure of the Constitution void. Without this, all reservations of particular rights or privileges would amount to nothing. You know, I've heard this phrase my whole life, and I've just never looked it up. ex post facto. I've never actually looked up what that means. Is a statute of that retroactively alters legal consequence, specifically by punishing actions that were legal. Okay. You can't do something and then make a law like, hey, that's illegal, and then punish you for it. Okay. I know that I've heard that term forever, but I never actually looked up what it means. Some perplexity respecting the rights of the courts to pronounce legislative acts void, because the contrary to the Constitution has arisen from imagination that the doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the ones that acts may be declared void, as this doctrine is of great importance in all the American constituents. A brief discussion of the ground on which it cannot be unacceptable. There is no position which depends on clearer principles that every act of delegated authority, contrary to the tenure of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above the master, that the representatives of the people are superior to the people themselves. That man acting by virtues of power may do not only what their powers do not authorize, but what they forbid. It is said that the legislative body themselves are the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments. It may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is not otherwise to be supposed that the Constitution could be intended to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority, that the interpretation of the laws is the proper and peculiar providence of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meanings, as well as the meanings of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred, or in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Nor does this conclusion by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, that the judges ought to be governed by the latter rather than the former. They ought to regulate their decision by fundamental laws rather than that are not fundamental. All right, so he's saying the judges are the representatives of the people against the legislature and the people are represented by the Constitution, so the Constitution takes precedent. Okay. All right. That was a lot on that one. But I like that one. The exercise of the judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with each other, and neither of them containing any repealing clause or expression. In such a case, it is the providence of the courts to liquidate and fix their meaning and operation, so far as they can, by any fair construction. be reconciled to each other. Reason and law conspire to dictate that this should be done. Where this is impracticable, it should become a matter of necessity to give effect to one, in exclusion of the other. The rule which has obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. But this is mere rule of construction, not derived from any positive law, but from the nature and reason of a thing. It is a rule not enjoyed upon the courts by legislative provision, but adopted by themselves as a consonant to truth and propriety for the direction of the conduct as interpreters of the law. They thought it reasonable that between the interfering acts of equal authority, that which was the last indication of its will should have the preference. But in regard to the inferring acts of superior and subordinate authority, of original and derivative power, the nature and reason of a thing indicate the converse that rule as proper to be followed. They teach us that the prior act of superior ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, whatever a particular statute contrivances the Constitution, it will be the duty of the judiciary tribunals to adhere to the latter and disregard the former. It can be of no weight to say the courts, on the pretense of repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature. This might as well happen in the case of two contradictory statutes, or it might as well happen in every adjunction upon a single statute. The courts must declare the sense of the law, and they should be disposed to exercise will instead of judgment. The consequence would be equally to the substitution of their pleasure to that of the legislative body. The observation, if it prove anything, would prove that there ought to be no judges distinct from that body. If, then, the courts of justice are to be considered as the bulwarks of a limited constitution against the legislative encroachments, this consideration will afford a strong argument for the permanent tenure of judicial offices, since nothing will contribute so much to this as the independent spirit of judges, which must be essential to the faithful performance of so arduous a duty. This independence of the judges is equally requisite to guard the Constitution and the rights of individuals from the effects of those ill humors, which the arts of designing men, or the influence of particular conjunctures, sometimes disseminate among the people themselves, and which, though they speedily give their place for better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous innovations in the government and serious oppressions of the minor party in the community. Though I trust the friends of the prose Constitution will never concur with its enemies in questioning the fundamental principle of little r republican government, which admits the right of the people to alter or abolish the established Constitution whenever they find it inconsistent with their happiness, yet it is not to be inferred from this principle that the representatives of the people, whenever a momentary inclination happens to lay hold of the majority of their constituents incompatible with the provisions in the existing Constitution, would, on that account, be justifiable in a violation of those provisions, or in the courts would be under greater obligation to convene the infractions of this shape than when they have proceeded wholly from the cabals of their representative body. Until the people have, by some solemn and authoritative act, annulled or changed the established form, it is in binding themselves collectively as well as individually, and no presumption or even knowledge of their sentiments can warrant their representation and departure from it prior to such an act. But it is easy to see it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative innovations have been investigated by the major voice of the community. Oh my God, this is a long one. This is going to be my last one for the night. But it is not with a view to infractions of the Constitution only that the independence of the judges may be essential safeguard against the effects of occasional ill humors in society. These sometimes extend no farther than to injure the private rights of particular classes of citizens by unjust and partial laws. Here also are the firmness of the judiciary magistrate of the vast importance in the mitigation of severity in confining the operation of such laws. It not only serves to moderate the immediate mischiefs of those who may have been passed, but it operates as a check upon the legislative body in passing them, who, perceiving that obstacles to the success of iniquitous intention are to be expected by the scruples of the court, are in a manner compelled by the very motives of the injustice they meditate to qualify their attempts. This is a circumstance calculated to have more influence upon the character of our government than but a few may be aware of. The benefits of the integrity of the modern judiciary have already been felt in more states than one, and though they have displeased those whose sinister expectations they have disappointed, they must have commanded the esteem and applause of all virtuous and disinterested. Considerate men of every description ought to prize whatever will tend to beget or fortify that temper in the courts, as no man can be sure that they have to be tomorrow the victim of spirit of injustice by which they may be a gainer today. And every man must now feel that the inevitable tendency of such a spirit to sap the foundations of public and private confidence, and to introduce its stead universal distrust and distress. That inflexible and uniform adherence to the rights of the Constitution of individuals which we perceive to be indispensable in the courts of justice can certainly not be expected from judges who hold their offices by a temporary commission. Periodical appointments, however, regulated or by whomever made, would in some way or another be fatal to their necessary independence. If the power of making them was committed either to the executive or the legislature, there would be danger of improper compliance to the branch which possessed it. If to both, there would be an unwillingness to hazard the displeasure of either. If to the people or to persons chosen for them for this special purpose, there would be too great a disposition to consult popularity to justify a reliance that nothing would be consulted by the Constitution and the laws. All right, almost done. There is yet further and weightier reason to the permanency of the judicial offices, which is deducible from the nature of the qualifications they require. It has been frequently remarked that with greater propriety that the voluminous code of laws is one of the inconveniences necessary to the connected with the advantages of free government. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules of precedence, which serve to define and point out their duty in every particular case that comes before them. It will readily be conceived that the variety of controversies which grow out of the folly and wickedness of mankind, that the records of the precedents must unavoidably swell to very good considerable bulk, and must demand long and laborious study to acquire a competent knowledge of them. Hence, it is that there can be a few men in the society who will have sufficient skill in the laws to qualify them for the stations of judges, and making the proper deductions for the ordinary depravity of human nature. The number must still be smaller than those who unite the requisite integrity with the requisite knowledge. These considerations apprise us that the government can have no great option between fit character, and that the temporary duration in office, which would naturally discourage such characters from quitting a lucrative line of practice to accept a seat on the bench, would have a tendency to throw the administration of justice into the hands of less able and less qualified to conduct it with utility and dignity. In the present circumstances of the country, and in those in which it's likely to be for a long time to come, the disadvantages on this score would be greater than they may be at first sight appear. But it must be confessed that they are far inferior to those which present themselves under the other aspects of the subject. Upon their whole, there can be no room for doubt that the convention acted wisely in copying from the models of those constitutions which have established good behavior as the tenure of the judicial offices. In point of duration, and that so far from being blamable on this account, their plan would have been inexcusably defective. If from wanting this important feature of good government, the experience of Great Britain affords us illustrations, illustrious comment on the excellence of the institution. All right, that is number 78. I probably should have stopped at the last one. That way, next time can be all judiciary. Oh, man. 80. Oh, crud. The next bit is really long. Oh, boy. I don't think I can do all that next time. The judiciary is going to be 2 more parts. All right. But that's good enough for tonight. I had fun. I hope you got something out of that. I will be either back tomorrow or next week. If you want to learn more about the Federalist Papers, why they wrote the Constitution the way they did in their own words, I will be back next week to do this again. Hope everyone had a good time. I'll drop a follow so you can catch up.